Hello and welcome. Look, if you're studying South African criminal law, you already know just how much there is to get through. So think of this as your go-to study guide. We're going to break down all the core concepts to make sure they actually stick, especially when you're gearing up for an exam. All right, let's jump right in. Okay, first things first, we have to know the difference between a civil case and a criminal case. It's pretty simple when you think about it. On one side, you've got a private argument. Your neighbor's tree messes up your fence. That's a civil matter between you and them. But on the other side, someone breaks into your house. That's not just a problem for you, it's seen as a wrong against the entire community. That's a criminal case. And honestly, the single distinction is the foundation for everything else we're about to cover. So here's our game plan. We'll start by digging deeper into that criminal versus civil law difference. Then we'll look at where our criminal laws actually come from. After that, and this is super important, we'll break down the three essential ingredients of any crime, with a special focus on fault. And finally, we'll talk about the consequences, everything from cause and effect to punishment. Okay, let's get into Section 1, Criminal versus Civil Law. We're laying the foundation right here. This table really lays it all out perfectly. In a criminal case, who are the parties? It's the state taking on an accused person. But in a civil case, it's just one person or company against another. Now, the burden of proof is also totally different. The state has to prove you're guilty in a criminal case. In a civil case, the person making the claim has to prove their side. But here's the most critical difference, the one you absolutely have to remember, the threshold. A civil case just needs a balance of probabilities. Think of a scale just tipping over 50%. But for a criminal conviction, the proof has to be beyond a reasonable doubt. That scale has to be slammed down on one side with no other logical explanation possible. And all of this leads to the aim. Criminal law wants to punish, so you get a guilty or not guilty verdict. Civil law wants to find a remedy, so a case is either allowed or dismissed. Right. On to Section 2, Sources and Categories of Crime. You can think of this as us looking at the actual blueprints of our entire legal system. So where does all this law even come from? Well, it flows from three main sources. First, you've got legislation. This is when Parliament passes an act creating specific written-down crimes. These are called statutory offenses. Second, there's the common law. This is our ancient, unwritten legal DNA, giving us those crimes we all know, like murder and theft. And third, and this is so important, we have case law. This is where courts interpret those laws and apply them to new situations, which keeps the law alive and relevant. So basically, Parliament writes the new rules, tradition gives us the old ones, and the courts figure out how it all works in the real world. To help make sense of all the different crimes, lawyers usually sort them into four big buckets. First, you have crimes against a person. Think murder or assault. Second, crimes against property, like theft or robbery. Third, crimes that are against the state itself, with treason being the classic example. And finally, you've got crimes against the community, which are acts that harm our shared public life, like public indecency or even corruption. All right, now we're getting to a concept that is absolutely 100% critical for any law exam. Section 3, the three elements of a crime. And I want you to burn this into your brain. For any crime to exist, all three of these building blocks must be there. And here they are, the three pillars: an act or an omission, unlawfulness, and fault. You need all three, no exceptions. First, there has to be an act. But, and this is crucial, it can also be a failure to act when you had a legal duty to do so. A classic case here is S.V. Russell, where a person failed to warn others about a danger he was responsible for. That failure to act was the crime. Second, the act has to be unlawful. This means there's no valid excuse for it. If you acted in self-defense, for example, your act isn't considered unlawful. And finally, number 3, there must be fault. The person must be blameworthy in the eyes of the law. Okay, so let's zoom right in on that third pillar, because it's often the trickiest. Section 4 is all about understanding legal fault. We're moving away from the physical act and taking a deep dive into the accused person's mind. So what does the law actually mean by fault? It's not just about, being a bad person. In criminal law, it has a very specific two-part definition. And these are the two forms of fault you absolutely have to know: intention and negligence. And for your exams, you gotta know the Latin. For intention, think of a doleful or deliberate act. That's dolus. For negligence, think of being culpable or responsible for a mistake. That's culpa. Let's break both of them down. Okay, let's get into intention, or dolus, because it's not one size fits all. It actually comes in 3 different flavors. First, you have dolus directus, or direct intention. This one's easy. The result was your main goal. Simple.
Second is dolus indirectus, or indirect intention. Here, the bad outcome wasn't your primary aim, but you knew it was a practically certain consequence of your actions. But the one that always comes up in exams, the trickiest one, is dolus eventualis. This is where you don't necessarily want the bad thing to happen, but you foresee it as a real possibility, and you recklessly go ahead anyway. You basically reconcile yourself to the risk. The classic example? Someone fires a gun into a crowd. They might not be aiming at anyone specific, but they know it's possible someone could die, and they pull the trigger anyway. That is dolus eventualis.
So the other kind of fault is negligence, or culpa. Now, unlike intention, this isn't about what was going on in the accused's head. It's an objective test. The court asks a simple question. What would a reasonable person have done in that exact situation? And this reasonable person is just a legal yardstick. They're careful but not paranoid. If the person on trial acted with less care than that reasonable person would have, they are considered negligent. And the case you need to remember for this is S.V. Dubé. Okay, so once the state has proven all the elements of a crime, what happens next? What are the consequences? That brings us to our final section, causality, punishment, and sentencing. Now, for certain crimes, and murder is the perfect example, there's one more piece you need, a causal link. This is the direct chain of cause and effect connecting what the accused did to the final result. The prosecution has to show that the act caused the death. But if something else comes along and breaks that chain, some new intervening event, then causality is broken and the accused can't be found guilty of murder. This might seem like a silly question, but why do we actually punish people? The law gives us 5 main reasons, and sometimes they even contradict each other. We punish as a deterrent, to scare off other would-be criminals. For prevention, which is just locking someone up so they can't harm anyone else. For rehabilitation, to try and fix the person. For revenge, sometimes called retribution, which is about society getting even. And finally, for restoration, which tries to repair the harm that was done to the victim and the community. And when it comes to deciding what punishment to give, this is the magic formula. It comes from the famous case of Zes v. Zinn, and it's known as the Zinn triad. A judge has to perform a really delicate balancing act between 3 things: the crime itself, the criminal, and the community. They have to weigh how serious the offense was, look at the offender's personal circumstances, and consider what's best for society. It's this triad, plus any aggravating or mitigating factors, that leads to a sentence.
So, after doing that Zinn triad balancing act, the court has a whole toolbox of punishments it can use. These are the most common ones you'll see in South Africa. Good old-fashioned imprisonment, periodic imprisonment where you might just serve weekends in jail, a suspended sentence, a simple fine, or correctional supervision, which is basically a form of house arrest. The punishment all depends on that balance.
And one final, crucial point you have to know. What about the death penalty? Well, in the landmark case of S.V. Makwanyane, our constitutional court ruled that capital punishment is unconstitutional. Why? Because it was found to be a cruel, inhumane, and degrading punishment. It is officially abolished in South Africa, full stop. So, let's end with this little puzzle. We just saw that revenge is one of the official goals of punishment, but the ultimate form of revenge, the death penalty, has been declared fundamentally unjust and illegal by our highest court. So, what does that contradiction tell us about what justice is really trying to achieve in our country? That's definitely something to chew on long after your exams are over.